It's nice to see some familiar faces and some new faces. For those of you that don't know me, I'm Carla Murray, and I head the commercial and tech team here at Myerson. And I have over 17 years actually, experience in technology law and commercial contracts. And my co-host for the morning is Richard Meehan. Richard is a senior associate in our commercial and tech team, and he also has extensive experience in technology contracts, so you're in safe hands today. So given it's been a while since we've had a seminar and we've now established our tech team for a number of years, I thought that I'd introduce the tech team to you all, because those of you that have attended our seminars in the past will recall that it was myself and Tim Norman that used to present them, and Tim sadly retired from the firm earlier this year. So I will take the opportunity to introduce you to the wider tech team. So we have Patrick. Patrick is from our employment team, and he advises on worker status and engaging self-employed contractors. We also have Jack. Jack's from our litigation team. He advises on tech disputes, and as lovely as Jack is, if we have to send you upstairs to Jack, you know things are going a little bit wrong. And finally, we have some of our other homegrown experts, Olivia and Karen. Both are former trainees with the firm and qualified into the commercial team to assist myself and Rich with commercial and technology contracts. And that makes up the tech team. So today's agenda, we're going to have a look through project management and contracts. Rich will then guide you through controlling your contract exposure. I'll have a look at SaaS before we then hand everything over to the AI bots and see what they have to say about things. It's going to be a whistle-stop tour, so brace yourselves. And hopefully by the end of the session, you'll all have at least 3 or 4 key takeaway points, if not a few more, to think about when considering tech contracts. We have less time for a Q&A session at the end, so for those of you joining online, please do send through your questions, and we'll try and get through as many of those as we can before we finish. So, starting things off on the right foot, we can't underestimate the importance of starting your software project off on the right foot. Whilst it may seem a bit of a trudge going through the legal process, what it does is it can avoid uncertainty at a later date and disputes arising. So you then may therefore wonder, well, how early is too early to get somebody to sign up to a contract with you? And the simple answer is never. It does depend. I think what you need to think about is those really early initial stage discussions. You know, you might have vendors or customers that you're talking to kick off a project. And what you need to be thinking at that very early stage is, do I need to put an NDA or confidentiality agreement in place with them? Because what may seem like really innocuous discussions, you know, could actually very quickly turn into really detailed discussions about, you know, your systems, your protocols, operations, ideas, you know, applications that you're looking to develop. And as the discussions progress, you could find that you're actually disclosing a lot of your confidential information and trade secrets to the other party. And once the cat's out of the bag, you know, once you've disclosed that information to them, what's to stop them sharing it with another person? Apologies. We have now gone the wrong way. And you know, the other point is, what if you disclose your intellectual property rights? You know, unless you have a confidentiality agreement in place with somebody, then there is nothing to stop that person disclosing it to others. And so that's where the protection of an NDA comes into play. As a well-drafted NDA will be clear on what basis the confidential information is being shared, who the third party can share that information with, and for what use it can be used, and also will protect your intellectual property rights. You know, it will make it clear that no rights are being assigned under the NDA, and that all of the intellectual property rights remain vested with your business, which may seem really, really obvious, but experience, I have reviewed NDAs where the client's been happy with them, and you read it, and there's a clause in there that's actually assigning the client's IP over to the other party. So we've got a red pen and struck that clause right out. So, you know, it can happen. So we've got our NDA in place, then we're moving on to more of the commercial discussions and part of agreeing the commercial. And this is where the fun really begins. You know, we often get inquiries from individuals saying, oh, well, we've agreed the commercials, we just need this reflected in the contract. It's like, brilliant, great, okay. We'll do a bit of a deeper dive then into what's been agreed. And actually what you find out is the parties just have 3 or maybe 4 high-level principles that they're agreeing to commit to, but then they haven't thought about more of the complex nature of you know, what's to be put into the agreement, whether that's the contract structure, who owns the IP rights, how's liability going to be catered for. And it's at that point that parties really should be thinking about, do we want to have a heads of term or memorandum of understanding put in place, or do we move straight on to the model contract? Are we just going to issue our standard contract to the other side? And the approach you might want to take does often depend on what solution is actually going to be provided. You know, is it standard software that's being implemented? You know, that's really straightforward to roll out and implement, where the terms are unlikely to be negotiated. And if that's the case, you may find that you as a supplier want to use your standard terms, or as a customer, you know, the supplier is sending over their standard model contract. And a way of kind of aiding in the acceptance of this is it can be presented as a click-through acceptance, or as a DocuSign agreement where you can't amend it, you're just required to sign the agreement and accept the terms. And Darren, I know you're familiar with the benefits of DocuSign. We like that, don't we? So yeah, that can help, you know, just push things over the line. However, that approach might not be appropriate if, for example, the solution that you're implementing is bespoke, if it requires extensive implementation and adaptation configuration to be done, if it requires workshops for user journeys to be mapped, you know, if it's got some element of pre-go live works that are needed, then the parties might not be at that stage where they're ready to commit to a full software supply agreement and actually start thinking about, well, head terms are where we want to go to agree the commercials. And head terms can set out high-level principles. So, you know, they may set out what software license and structure has been agreed between the parties, the number of users that are permitted, may touch on IP ownership and some of the commercials if they're known at that time, and other milestones that are to be delivered in the lead up to the contract. Or they can be extremely detailed. Rich and I have both drafted terms where we're required to put the entire content of the clauses that would go into the main contract in the head terms for the parties to agree, and have fixed positions, for example, on indemnities, warranties, or liability caps. And the risk with that is you can get bogged down in almost negotiating the full contract for what's supposed to be head terms, and it can take time to get to those positions. But the benefit is then it can avoid, you know, further negotiations at the point of the contract being presented to the client, because those principles and provisions have already been agreed at the outset. I think a word of warning and caution here, though, is if you do have a detailed heads of term and provisions that are going to be put into the contractor within that, or if you have, you know, a light touch set of heads of term, if you then mobilise to doing the implementation and start providing the software without having that signed contract in place, you then risk yourself being in this situation where you've got a quasi-legal agreement in place. So you're acting on the basis of the terms, but you don't have all the full benefit of a properly negotiated contract in place. And that may cause you to need Jack's help. I just briefly wanted to mention project services as well. Project services contracts are a useful tool, where you may require consultancy services or workshops or analysis by a third party on your systems and guidance on solutions that you may be implementing. So if, for example, you engage a third party to come and evaluate your systems with a view to potentially migrating over to their software, then you might want to have a services agreement in place, particularly if there are charges to be paid for that service provision. Because the initial project is not always guaranteed to lead on to the full software licensing and supply agreement. And what the project services agreement allows you to do is ring fence your liability for that service line delivery. And it provides a natural break in the relationship for both parties to not have to commit to a long-term supply arrangement if we're not sure the solution is going to be right for our business. And a final word of warning on that as well: if you are engaging third parties to provide deliverables for you, then you need to consider who will own the intellectual property rights in those deliverables, because unless the agreement states otherwise, then it will be the third party that retains ownership of the IP that they develop for you, even if you've paid for that development. So for the ownership of intellectual property rights to transfer across to you, they need to be formally assigned in writing to your business. And if the agreement is silent on this, then you're just going to have an implied license to use that IP for the purpose. So again, there's a potential for creating uncertainty. So we've got our contracts, it's all negotiated, everybody's signed, everybody's happy. What do you do with it next? Well, what you don't do with it is file it in your virtual filing cabinet and hope that you're never going to need to look at it again. As tempting as this may seem, the contract should really be used as a tool to monitor what's being delivered under the contract. And a prime example of this is, your acceptance process and acceptance testing. You need to ensure that that acceptance process is followed, because sign-off will be measured against that. And there may be specific time limits in which retesting is to take place, or there could be a default position that if you don't notify of issues and clearly state that acceptance hasn't occurred, you're deemed to have accepted the software. And acceptance testing and following the procedure is important, because if the software does fail to meet those acceptance criteria thresholds, then from a supplier's perspective, it can withhold payment from yourself. Payment may be contingent upon that software solution going live. And if you don't get to that go live point, then obviously, you might not get paid for the work done to date. And the flip side, from a customer's perspective, is if the solution's deemed to have been accepted, you could find yourself in a position where you've got software that doesn't operate as anticipated, and the supplier's obligations are simply then to just provide support under the support SLAs and a reasonable endeavours obligation to provide that support. And so then where you find yourself is a piece of software that's not doing what you need it to do, but also being obliged to pay charges under the contract. Other things that the contract will cover off will be, change control processes, and a good change control provision will set out how the parties can make changes to both the software, to services that are provided, and may cover off what the cost implications are for this. And such provisions will then allow the parties usually to update and amend the contract to reflect how the software's developed and changed over time, and make such changes as necessary to the contractual terms. Another key reason, to keep the contract at hand is service levels. Uptime SLAs are typically 99% of the time. However, what you need to be mindful of with SLAs is what time falls outside of this uptime, because maintenance windows tend to fall outside of uptime calculations, and that can leave you with a large period of unavailability of the software. You should also think about, what rights are available if the SLA is not met. Is it that service credits are applied? You need to think about, well, how will they be applied? Do you have to follow a formal process to request the service credit? Or is it automatically just going to be credited to your next invoice? That's a very rare standard position. It's unlikely that a supplier is going to, offer you that off the bat. And And the other thing to think about is, are service credits appropriate? What if the service dropped below a 95% availability level? What rights do you as a customer have? On the face of it, 95% may seem a reasonably high level of availability, but you need to think about that. Is it really a high level when you're measuring against a 24 hours a day, 7 days a week availability time window? Technically, if the downtime falls during working hours, you could be out for almost 3 days and only just be hitting that 95% threshold. And that could have a massive impact in your business operations if you're without your software for that period of time. So as a customer, you may want to push for service availability to be measured during your core business hours. Obviously, from a supplier's perspective, having uptimes measured just during core business hours massively reduces the hours that the software can be down and your fixed times. And it might be difficult to achieve if the software is being provided across multiple time zones. So you then need to think about, do I have the infrastructure in place to offer a true 24/7 support service? So those are just a few sort of things to think about in terms of service levels. And tying into all of this is contract governance. A well-drafted governance schedule will set out, what the parties are to do to make sure the contract keeps on an even keel. It will include things such as regular review meetings, project managers to meet and discuss issues, to have that time where things can be discussed before it starts escalating and starts to impede business operations. And then we need to start looking at, okay, this has gone from governance to dispute resolution. What are our dispute resolution mechanisms under the contract? So it helps to encourage good behaviour from both supplier and customer's perspective, and just iron out any little issues and problems at the onset. Ultimately, as the quote says, what we really want at the end of the day is not to be stuck with technology. We just want something that works and makes our lives a little bit easier, which leads us nicely on to Rich's considerations of how to control your contract exposure.
Thank you, Carla, and thank you everyone for being here today. In this part of the session, we'll be considering something that we spend a lot of time talking with our clients about, since it's often the key driver for them engaging with legal in the first place. How do we control exposure through our contracts? So we'll talk a little bit about what we mean by exposure in this context, and then think about how the written contract can help to control the risks. And to a degree, it's the flip side of what Carla's been talking about. If she's been talking about how we can positively use the contract to improve how working relationships go, what I'll be talking about is probably the things where we'd ideally have the clauses in the contract and then leave them in the drawer, because nobody wants to start looking at the liability clauses if they don't have to. But things do go wrong, and when they do, businesses are often glad to have contractual protections to rely on. So in this context, when we talk about exposure, we're talking about the manifold risks that a tech business invites when it starts to trade. And we often think about exposure to the other party to the contract. What can my customer sue me for if the platform doesn't perform? But it's not just a supplier issue, it's also a customer issue. You have to be conscious of the liability that the customer could incur to the supplier if there's a breach of license terms, or indeed additional charges. Needs careful review in the contract. Equally, it's not necessarily about the other party to the contract. It might be regulatory risk. So a telecoms provider needs to be aware of the Ofcom general conditions of entitlement, for example. Or it could be liability to a third party. It could be an individual data subject who brings a claim against somebody who processes their data. The contracts that the parties put in place do give them an opportunity to regulate that exposure and allocate it as between themselves. When we carry out a contract review for a client, one of the things we'll flag, we'll say this is a risk in the contracts and it's treated as unlimited liability. And that tends to elicit a sharp intake of breath. I suppose it's worth just noting that unlimited liability is the natural state of things. It's where we start. It's only once you put that contract in place that you have the opportunity to say, we are actually going to contractually limit our liability as between ourselves. As you'd expect, we're lawyers, so we'll talk a little bit about caps and exclusions on liability, which I'm sure is the part of the session everyone's looking forward to. We'll also talk about some of the other tools within and outside the contract that can be used to control exposure. If we start, though, with the caps and exclusions, essentially with a cap on liability, we're looking to place some kind of limit on the financial exposure of one party to the other if a matter giving rise to a claim arises. It could be a fixed sum, or it's often pegged to the value of the contract in some way. And we'll look at an example of that on the next slide. Exclusion of liability, on the other hand, that's an attempt to identify a kind of loss, or multiple kinds of loss that could arise, and say that if that is the kind of loss that one party has suffered, they're agreeing that they're not going to claim for that kind of loss from the other party, even though the other party caused it. So a provider of a tech solution might say, well, if the platform doesn't work, I accept there's some kind of liability I might have. There'll be claiming damages, there might be compensation, but I'd like to think it's limited to the cost of repairing the platform or potentially replacing it. I might not want to be exposed to the costs that the customer suffers in terms of their lost profits or the reduction in profits that they suffered while my platform wasn't allowing them to trade as usual. So you get a very common type of exclusion of liability, loss of profits. That's a common negotiating point as well. In both cases, caps and exclusions, what we're trying to do is to say, even though the courts might be prepared to award a greater sum of damages or to allow the recovery of losses in respect of different categories of loss, as a matter of contract between the parties, we are going to say that's the limit, that's the financial limit that applies, or these kinds of losses are off the table. For it to be effective in doing that job, it needs to be clearly drafted, unambiguous, so that the courts are going to be willing to apply it if they're asked to limit the damages which they'd otherwise be minded to apply. This is the only bit of case law in this morning's session. But we do like to do this kind of thing. We wouldn't want you to go home thinking you'd been shortchanged. So this relates to, it's an ongoing dispute between Drax, the energy company, and Wipro, who are a big tech provider, Indian-based global provider of tech solutions. It's a nice one to speak about because it's live. So these clauses were looked at in June by the High Court, but the main claim is still ongoing. And it relates to an IT project, implementation of an Oracle-based solution. No spoilers, but it didn't go to plan. And also it illustrates the importance of clear drafting in a clause capping contractual liability. So of course what we've got on the screen is the liability cap clause, and that's what we'll think about as we look into this. Without going into the detail of the background, suffice to say, Drax, the customer, brings a claim against the supplier, Wipro, alleging a range of deficiencies in terms of how the project has gone, and claiming for losses in the order of 31 million is what how they value their losses. Before we get to the hearing of the main issue of whether there is liability for that, the court is asked to look at these clauses, among others, and they're asked to do that so that the parties can get an understanding of what the cap on liability in this contract is. Sorry, I'm probably in your way, but you've got them there. So they're looking at these clauses. The issues arose in the first contract year, so we're on this bit in red. 150% of an estimate of the charges paid and payable for a full 12 months. And parties agree that's about 11.5 million, which is a big enough number, but it's a lot lower than 31 million that's potentially being asked for. The point that Drax's lawyers raised, though, relates to the second bit in red. They say, okay, the clause talks about the liabilities being limited by reference to amounts paid or payable in the preceding 12 months from the date the claim first arose. But they say, we don't have a claim. We've got lots of things that have gone wrong, and we've got lots of causes of action. So, the date the claim arose, perhaps what this clause is really trying to say is that whenever there's a claim, you do a 12-month count back. And there you go. There's your liability cap for that claim. If that's the case, then obviously each of the claims gets its own bite of the cherry. And the clause that Wipro is looking to rely on becomes way less effective in limiting their exposure. Based on Drax's argument, you come to a potential liability of up to 23 million from what they were pleading. So the question then boils down to whether this clause creates a single aggregate cap on liability or multiple per claim caps. I'll resist the temptation for a show of hands, but you might have formed your own opinion on this. The court decides, after giving the clause quite a going over, in fairness, that it has to be read as a single aggregate cap on liability. And they get to that conclusion. I always quite enjoy these things because it's about reading the English language and assessing what it means. They come to that conclusion by saying, well, the clause starts off by talking about the supplier's total liability to the customer. So that feels like an attempt to talk about total aggregate liability. And then they look precisely at the wording that Drax's lawyers have been pinning their case on, really, this business of the charges paid or payable in the preceding 12 months from the date the claim first arose. And they say that clause 33.3, which is another clause dealing with liability, but specifically data protection liability, they say that that clause, everyone agrees, is a single overall aggregate liability for that kind of liability. It talks about being total aggregate liability. It refers to liability for any and all claims. And they say, well, 33.3, everyone says that's overall aggregate for that type of liability. And that uses the same wording. It again talks about the charges paid or payable in the preceding 12 months from the date the claim first arose. So if it's used there, it shouldn't be determining that the preceding clause, 33.2, was intended to be a per claim cap. So it's an interesting bit of reasoning. It shows how the courts will get into the detail of these kinds of clauses. I was on the other side from Wipro in a contract negotiation a few years back, and they were very pleasant to deal with, so I've read this and I was pleased to see that their liability cap clause had just about got through, but probably not as pleased as they were. Other contractual clauses and tools to be aware of. Force majeure. Every contract should deal with the topic of force majeure, because if it's not there in the contract, there's no overarching principle that it will be there. It's not implied by law or common law. And the aim of this kind of clause is to say if a party is prevented from performing its contractual obligations by something genuinely beyond its reasonable control, the classic act of God kind of scenario, then they get relief from the obligation to perform that service or whatever the obligation is. They can't be sued for failing to do it. The challenge with force majeure clauses, of course, is that by their nature, it's hard to predict the scenarios where they're going to come into play. You go back to 2010 and we have the volcano erupting and preventing air travel. Everyone starts looking at their force majeure clauses. A little more recently in 2018, we had a CO2 shortage, which almost disastrously prevented the supply of beer for the World Cup that year, but also impacted on, as it turned out, packaging crumpets and slaughtering pigs. Who would have thought? And again, everyone starts thinking about the concept of force majeure. More recently, of course, we've had lockdown. Now, tech businesses have been quite resistant to lockdown in many cases, not all, but in many cases. That said, it's very easy to imagine potential future scenarios beyond anyone's reasonable control that might well affect the infrastructure that bears so many tech services nowadays, and which would get people looking again at these force majeure clauses and asking, well, am I protected from the fact my service has gone down by whatever the incident is that's prevented it being delivered? I'll quickly pick up on the idea of using rights to terminate or suspend as a method of limiting exposure. Of course, what this allows you to do as a supplier, if you can terminate the contract or suspend your obligation to provide it in circumstances that suit you, then you're able to stop the accruing of a liability for something that's going wrong. So it is a useful tool to say, well, okay, we're going to draw a line under things at this point. We're going to terminate the contract or at least suspend our obligation. If we're not performing the services to the standard that's required, at least from this point onwards, we don't have a contractual obligation to do so. So it's a tool to limit exposure that way. Carla mentioned SLAs earlier and service credits as a potential remedy. So on the whole, you might think of that as a customer favouring provision because it gives a definite remedy on the event of some service failure. Equally, though, from the supply side, it's important to think about whether service levels and service credits can be calibrated at a level that you are comfortable with and can then also be treated as exclusive remedy for that kind of service failure. By doing that, they become effectively the cap on liability. And if they've been calibrated at a level that you're comfortable with as the provider, then you've achieved the objective of limiting exposure. Dispute resolution procedures are very useful to have in the contract and think about at the outset because they may well provide an opportunity for the parties to resolve an issue without having to go to court, without having to incur those costs and avoid the potential claim in damages. They have their own costs as well. So it's not a silver bullet, but it's often worth thinking about. And then finally, we'll talk about expressly allocating risks. Another favoured topic among lawyers is the use of indemnities in contracts. And an indemnity is an attempt between the parties to expressly say, this is a risk that might arise, and we want party A to bear it and not party B. In the tech context, you may be providing a managed service and maybe taking over from an in-house team that was previously doing it or from a previous incumbent supplier. In that scenario, the possibility of staff who were previously dedicated to providing that service for your new client transferring to you under employment law has to be considered. And that's needs consideration on a case-by-case basis, but it's often a matter that the parties will want to deal with through express allocation of responsibility, the costs associated with employees transferring and all that goes with that. Some wider considerations, though, because it's not all about what's in the contract. Due diligence. If you know who you're dealing with and the risks associated with them, you go a long way towards mitigating your own potential exposure. You can always consider the availability of insurance, and it's important to talk through with the broker how the policies you have in place could apply to the kind of exposures and risk scenarios that you're trying to deal with. And more generally, even than that, since prevention is better than cure, a well-drafted contract can help in ensuring that customers and suppliers understand what each is undertaking to do, what the tech solution does and what it doesn't, and importantly, what it doesn't do, what the customer dependencies might be or what the third-party dependencies might be, all of which gives the supplier a potential argument if something arises that they can say, well, it arose, it's a problem, but it is down to a third-party dependency which we identified in advance. It's down to you, the customer, not giving us something we needed. And clarity and understanding between the parties, as well as good performance against the contract requirements, is a key step in terms of mitigating the risk of liability arising. Very quickly on personal data. This is just by way of an example of a potential area of exposure which is relevant to all of the things we've been discussing so far. With personal data and the liability that might arise in respect of that, never is it more true than that the prevention is better than the cure. The cases and the liabilities that arise in respect of data protection arise because something has gone wrong. So practical prevention, which means the due diligence that we're talking about, ensuring that information security measures are implemented and using good providers with the relevant accreditation. Ensuring that any subcontractors you work with have the same standards so that you control liability through the chain. Insurance, the cyber insurance, I would flag it's particularly important in that field to check that the policy you're buying actually covers the kind of liability that you might suffer. That's well worth discussing with the broker. Clarity and understanding. Data protection laws and complying with them from the point of view of the contract is a lot to do with being clear about the roles and responsibilities of the different people involved, different parties involved. So is one party acting as the processor for the other, or are they both acting as controllers? Are they both making decisions about what data is collected and how it's used? So that needs to be correctly stated in the contract. And you need to understand the wider flows of personal data. So you've got a record of what data processing activities have happened. Have to think about international transfers of data and make sure the right contractual measures are put in place for that. And then finally, for my section, caps and exclusions in the context of personal data. One thing it's worth saying is that for a long time, data protection liability was one of the things in a contract where uncapped liability was accepted. It was with GDPR and a growing awareness of the risks and also an increase in the potential liability for data protection issues that parties started being much more focused on negotiating caps of liability for data protection issues. It's still the case, though, that data protection is one where a super cap or a higher level of cap is often agreed for that particular kind of liability, as we had in the Drax Wipro example. And a final point, from the customer's point of view, having gone to the trouble of negotiating a super cap on liability for data protection breaches to give yourself some more protection from the supplier if something goes wrong, it's important to check the exclusions of liability in the contract. Because you will very commonly, as I said, loss of profits is a very common excluded area of loss. Loss arising from loss or corruption of data is also very commonly seen. But from the customer point of view, there's a risk there that that excluded area of loss would prevent you from bringing your claim for the very thing that you're trying to protect yourself against in respect of a personal data breach and the personal data super cap. So preferable to say from the customer's point of view that the exclusion of liability for loss associated with loss of data doesn't prevent recovery in respect of a claim for a personal data breach or indeed a confidentiality breach. So that's that section on exposure. And now I'll hand it back over to Carla to talk about software as a service.
Thank you. So what we've got on the screen there is a really broad definition of software as a service. It's in the widest sense of the term. Ooh. Apologies. When you compare this with the narrow definition of SaaS, which is software provided on a subscription model basis, it's clear to see that SaaS itself has many connotations and nuances to it. And certainly in the time that I've been doing tech contracts, I've seen how SaaS agreements have changed over time. So I thought we'd just have a quick look at, is it SaaS and how can software be provided? Traditional software licensing involves software being installed on the customer's own on-premise servers, with the customer being granted the right to access and use the software for particular purposes within certain constraints. And as businesses have become more comfortable with the cloud and all that the cloud can offer them, we've obviously seen this upsurge in a variety of SaaS offerings, with the software being hosted on suppliers' servers, on third-party servers, or also customers procuring their own hosting services. So you need to think about what the key differences ultimately are in relation to those two arrangements. And the point being is who has access to the source code. In the traditional licensing model, the supplier is parting with its physical ownership of that source code. It is giving the customer a copy of that and very much relying on the good behaviour of the customer to comply with the terms and to not do anything untoward with that source code. Whereas with the SaaS, it's behind a further wall. They're not given the copy of the source code. It, to a certain extent, remains with the supplier. But as I say, we have this kind of hybrid SaaS model where the customer may host the software on a third-party server. Well, for the customer to be able to host it within a cloud environment, the supplier needs to give them control of that code or implement it on that instance, as well as having ongoing access to it. So it's clear to see that can cause a bit of confusion between, are we on a traditional software licensing model or have we migrated over to SaaS? Where do the boundaries lie? And what the contract then needs to do is be really clear on hosting obligations and responsibilities. As a supplier, you need to consider if the offering you're providing, if you're procuring a cloud environment, are you also taking responsibility for that? Are you capturing that fully as your SaaS service? Or are you allowing the third party to just to have that responsibility? Are you wanting that to be as between the customer and the third party hosting provider? With getting those obligations right and set out is really important, because if you're simply procuring the environment, then what you need to do is think about, well, are we going to have the third party supplying it on their standard terms that we want to pass straight through to the customer? If you're taking responsibility, then you need to have an in-depth look over the hosting provider's terms, what they're committing to deliver to you, and then think about back-to-backing that with your customer to ring-fence your risk and liability, and make sure you're in a position where you're comfortable that if there is a risk to exposure, it's one you're happy to take. And the other thing to think about as well, as a software, from a software provider's perspective, is if your customer has procured the cloud environment, well, where do your support responsibilities start and fail? Who should be responsible for downtime? What if it's the cloud environment that's causing the issue? Where are those parameters? How does that have an impact? What if you can't roll out the updates or the customer's not doing things? It's about clarity of obligations, because we are in this situation where we can have platforms, multiple software connectivity, and it's being clear of where you're ring fencing your liability, where your responsibilities start and end, who's responsible for the API, who's responsible for ensuring connection points are up and running. All of those need thinking about and working into your contracts. Which brings us on to model service contracts that Rich is just going to touch on, some new government issued documentation.
It's only really by way of an acknowledgement of the increasing prevalence of SaaS as a model, that within the model services contracts, which are issued by Cabinet Office and the Government Legal Department for use by government bodies when they're carrying out public procurements, within those models we have the acknowledgement of SaaS as one of the possible things that public bodies will be buying. So the intellectual property provisions in those model contract, in the model contract, have drafting options, and the screen indicates two of the traditional ones, option 1 and option 2, where the authority, the public authority, is going to own all specially written software and project-specific IPRs. So anything that's developed for the project, they're going to own. Option 2 acknowledges that there could be some commercial rights granted back to the supplier for commercial exploitation, but they're fundamentally traditional customer owns intellectual property rights. But option 3 is the one to purposes, and that's been introduced into the model contract. Covers a situation where there's no clear benefit in the authority owning the specially written software and project-specific IPRs. But more importantly for our purposes today, it also covers where any specially written software and project-specific IPRs cannot easily be separated from the supplier's existing intellectual property, and then they give the example software as a service. So it's a nod from the model services contract that it's important to allow for the possibility of SaaS solutions being what public bodies want to procure, and to recognise the rights of the supplier in respect to that kind of product. So for the final part of today's session, we're going to talk about AI, which we would, again, be remiss not to talk about in this kind of session. We'll start with this cheery quote from Elon Musk in recent chats about the threat caused by AI. This final section of the seminar, we take I suggest a slightly light-hearted look at AI, but I do hope our future robot overlords will take that in the spirit in which it's meant. So we've done a session on things you ought to know about tech contracts, but perhaps don't, and we hope we've identified one or two. But what does AI say about what we should have done? So we asked Google's Bard, and it came up with this. I've slightly summarized it, and this is only the first half of its answer, but I think you get the gist. And equally, I think it's a good summary, possibly somewhat bland, but it hits the key notes. Tech companies often overlook or misunderstand the importance of contracts, can lead to costly legal disputes and missed opportunities. So there's our exposure and using the contract positively. So here are some key things that tech companies should know about contracts but may not be aware of. And then we get into this format that the AI responses like of the numbered points. And obviously, if you don't like that format, as always with AI, there's another format that they can throw at you. But those are their top 5, which again, I hope we've covered. The first one, of course, is clearly AI getting straight to the business of doing the lawyers out of a job. But equally, we totally agree with that. We're saying the same thing. Lawyers can be helpful. They give us that much. Can be helpful in drafting and reviewing contracts. But tech companies should be familiar with the basic principles. And we hope today's session has been helpful for those purposes. Not all contracts are created equal. They go on to talk there about the fact that there are a range of different types of contracts, ranging through from NDAs through to the main services agreements, etc. Contracts are negotiable. Very good. We'll look at AI's attitude to negotiating contracts in a second. Contracts are not set in stone. Well, I've included what they say on this one, just because we as a business at Myerson are a business unlike the AIs in this context. So we quite like to help tech companies when they periodically review their existing contracts to make sure that they are still meeting their needs. Always useful to have that as a reminder. And then breach of contract can have serious consequences. These AI generative engines are fantastic. But they cover the bases really well, but they always need to be viewed with a degree of suspicion because they have really very little care as to whether something is accurate or not, as long as it fits in with their model. And to finish today, we saw this on the BBC recently, article titled, "Can AI cut humans out of contract negotiations?" which I'm sure we'd all agree is something highly desirable. So this was BBC reporting of a demonstration by a business called Luminance, and they are a UK-based AI solutions provider. And what they did was they set up a demonstration, which the BBC reporter watched and reported on. And they had a laptop, which was the Luminance laptop, and that was going to negotiate on behalf of Luminance. And they got one of their clients to come along, and the client had another laptop running the same Luminance software, but it was acting for the client. And they ran the negotiations. So laptop A and laptop B negotiate the contract. They pick an NDA, which is an interesting choice, but they are going to negotiate the NDA. So before we do this, I'll say we are basing this solely on the BBC's reporting of this matter. Any comments we make about it are purely based on that. And yeah, what we're going to do is attempt to role play this. This is not heavily rehearsed, but since we are being laptops, I hope it's within our wheelhouse. So I will be the Luminance laptop, and Carla the client laptop, and the whole thing starts by with me throwing my standard form of contract across to Carla bot for review.
So yeah, computer reviews it and says, no, we don't like this 6-year term. Let's have 3 years instead. That's a really arbitrary decision. Why choose 6 years? Why choose 3 years? How's AI decided that that's the amount of time that the information is going to remain confidential for? Computer says no to Russian law as the governing law and changes it to English law. Can't really argue with the AI logic there, to be honest. And computer says, absolutely not, we're not accepting uncapped liability. Shows up for the client. Can't do that. Have 1 million liability cap instead. Again, where's the 1 million come from? What we thought about to get to that cap. Hold harness, we don't like that word in either. That's struck out of the NDA. That's it. And bot's finished reviewing the contract, sends it back across to Richbot for him to have a look.
Emailed back over, and it's now back with this laptop. I should say that when they were doing this demonstration, they had a screen at the back playing out what the computers were doing, how the negotiation was going. And it feels like a relatively leisurely kind of exchange of views. I imagine once this becomes the norm, it will all happen pretty quickly. But anyway, contract is back with me as the laptop. I'm apparently happy to take a view on the change of laws, so I wasn't wedded to Russian law. Perhaps I just picked that arbitrarily. I noticed we've got a 1 million liability cap, and I also noticed that my indemnity no longer has some wording which I liked, which was indemnifies and holds harmless. So I'll probably take a little offence at this, but then, one way or another, possibly I review the cases on hold harmless wording, I don't know. But I decide that the appropriate response is to accept that deletion, but in fact go back with a response that, okay, we've got a 1 million liability cap, let's make that a liquidated damages clause. Now, this is where we're a bit limited by the fact we're just based on the reporting on the BBC of what's happened here. But based on what they say, it sounds as though this response is that any breach of this confidentiality agreement is going to have a pre-assessed, determined liability of £1 million, which in the real world would be, I think, viewed as a little heavy-handed, and we don't know the context. But anyway, that is my response, and I mark it up and send it back to Carla.
Just watching Jack's face, he's completely agreeing with Rich there. He's like, what? Yeah, so I don't like the liquidated damages clause. No, that's not happening. That gets struck out. But whilst on that, I also actually want to reduce the scope of this liability cap. So you're only allowed to recover direct losses. So I'll make those changes and send it back over to Bot B. Happy that I'm comfortable we've reached a position that I can allow my client to sign off on.
So now the ball's back in my court. I'm presumably tut in annoyance at the unreasonable objections to the liquidated damages clause. But and I think about the exclusion of liability for indirect losses. One way or another, I come to a conclusion that I'm not going to get any further in this negotiation. Now, why the laptop isn't prepared to keep pushing this, it must have some kind of engine to know, well, this is as far as I'll get with this particular unreasonable opposition. So I weigh it up and I say, okay, we're agreed. Cordial exchange of emails between the laptops, and we ping the thing over to the humans for the clearly unnecessary final stage of human review. And the computers go back to planning world domination. This is very glib. The product sounds tremendous, and opportunities for the use of AI in legal tech are clear and will be embraced. So it's fascinating to see. It will be fascinating to know a lot more about what this product did. How did it reach those decisions? Was it, in some sense, machine learning what the negotiation positions that the two parties could accept would be? Or was it programmed in a way that does happen quite a lot nowadays to say, here are the specific issues that might come up, here are the things that this client wants to achieve. Maybe you put a weighting on them and say, well, we'll give that score of 10, we really want that, but maybe the liquidated liability clause only gets a score of 1. We'll have it if we can get it, but we won't. So that's the kind of thing that could be happening. Or it could be doing something much more generative and actually looking at the contracts that the two businesses have signed in the past and saying, well, we accepted it then, presumably we can accept it here, and actually demonstrating intelligence.
I think that's a really important point, Rich, though. It really does depend on what we don't know is what information's been fed into the AI to help it learn and to help it put everything into context. So, if it has been given contracts between the two parties before, then that would be gearing up towards a more intelligent thought process and client-specific contract being developed for the parties than just general bank of provisions and backstop provisions that might be thrown into the mix just because that's all that's on offer.
And the other thing that occurred to us is from experience and from working with in-house legal teams, the interesting thing about an NDA landing with you in the team is not generally the negotiation of the NDA itself. It's why are you asking us to approve this NDA? What's going on? Does it need legal input? Are you about to disclose all of the business's confidential information? rather than limiting it to what's strictly necessary for the purposes of whatever you're doing right now. So the NDA is often the tip of the iceberg, and what you're interested in is not the NDA but the iceberg. And what will be really interesting will be to find out when and if AI is going to get to the stage of seeing that NDA, spotting the iceberg. I think that's when we'll have some real concerns.
Yep. Yeah. So we've just got time for some questions now. Hopefully, we found that we've covered everything we said we would, and it's given you food for thought. So if there are any questions, then please do feel free to ask us. Are there any that have come through online? No. Good. We don't have to ask it. That's fine. Yeah. Okay. Well, thank you all for joining us. We are looking to run a few more sessions through next year, so we'll send out information on those as and when we're at a stage of being able to offer those seminars. So thank you.